Okay, folks. I assume everybody's settled in. The roll sheet will be going around during this class session, probably at the very beginning. At the time that you are viewing this lecture, I'm probably in the air somewhere between Oklahoma and Washington, D.C., or just landing in Washington, D.C. I've put together this lecture for you so that we don't have to miss a class period. I am also going to upload this to Blackboard. As well as the individual lecture slides themselves. This is the fifth lecture in the policing class, and we are going to discuss the rights of the accused. For obvious reasons, it's good for law enforcement officers to know what the rights of the accused are, not just for your own elucidation, but because you get asked questions about it all the time. As a police officer, you get asked questions by the public, by people who are accused by you or others of committing crimes. It's good to have the background knowledge. But also some of the rights of the accused apply directly to the police work that you do. So things like giving Miranda warnings would be an obvious example of something that a law enforcement officer does in their daily routine of arresting people on the basis of probable cause or with an arrest warrant. And then maybe interrogating them or trying to seek information about crimes that they committed or intend to commit. So we're going to go through the rights of the accused, and then at a certain point, we will transition, maybe not in this lecture, but in subsequent lectures, we will begin to transition. We've been talking a lot about criminal procedure, a lot about police procedure and what the legal restrictions on police authority happen to be, how we balance that with the protection of individual liberty. We've spoken a lot about the broadness of the discretion granted to the police by the courts over time, the historic expansion of the Terry v. Ohio case, as well as other potential restrictions on police power. You're also probably going to realize as you watch this lecture that there is a lot of deference to the courts, not just the police, but also the courts, and to legislatures in how they decide to handle crime. Okay. So the rights of the accused. The Sixth Amendment reads, in all criminal prosecutions, the accused shall enjoy, and then it gives us a laundry list of different rights that the accused have. The first, highlighted in yellow, the right to a trial, obviously, and then highlighted in green that this trial must be speedy and public. Okay? So constitutional right to a speedy trial, constitutional right to a public trial. You also have the right to an impartial jury by the state and district wherein the crime was committed. Okay, so we'll talk about when jury rights attach to criminal actions. And the right to be informed of the nature and cause of the accusation. One of the things that you see in a lot of books about criminal procedure, books about the rights of the accused, is a Latin phrase called habeas corpus. Habeas corpus. The most direct translation of habeas corpus means to show me the body. And what it literally means, it's not referring to a murder victim or something like that. It means show me the body of law under which I have been arrested. So one of the rights of an arrestee, and maybe one of the first actions of his or her defense attorney, is going to be to file a writ of habeas corpus, to make the government show the law under which the person is being held and why they believe that this person has violated that law. Especially for people who are detained for a long period of time or arrested, but there hasn't been an arraignment. If you're getting impatient, maybe you file a habeas corpus petition to make the government show the reason for the holding. Okay? And you have a right to know under the Constitution what law you've been arrested under. Keep in mind, the Sixth Amendment, along with every other amendment to the Constitution within the Bill of Rights, the first 10 amendments, was a direct reaction to perceived government overreach on the part of Great Britain before and during the American Revolution. So almost everything listed in the Bill of Rights were prior identified abuses of power from King George and his officers against colonists in the original 13 colonies of the United States, which is to say, it wasn't uncommon necessarily for people to be arrested but not have the right and not be informed of the nature and cause of the accusation. So arrests without rationale, no habeas corpus rights. Okay. So we embodied this in the Constitution to protect the citizens. In blue, you have the right to be confronted with the witnesses against you. The witnesses might include the victim. What is be confronted with? Ultimately, the interpretation has been interpreted to mean that you get to cross-examine them in court, or your counsel gets to, so that you can poke holes in whatever they say they saw. And then after the semicolon, to have compulsory process for obtaining witnesses, that means subpoena power. So if you believe that there is somebody who has direct information about a crime that you may or may not have committed, as the defense, you also get to call your own witnesses, and you can make them appear even if they don't want to, or even if they find it inconvenient, by having them subpoenaed by the court. What does this mean? It means that once that witness receives a subpoena in the mail, that they don't get to ignore it. They have to show up to the trial and be cross-examined, and they don't have a choice. And in fact, ignoring the subpoena can result in its own criminal sanctions, which are not very pretty. So people generally follow what subpoenas say. Sometimes witnesses who have concerns about their own potential criminality might secure counsel of their own because they might be worried about their Fifth Amendment rights against self-incrimination. And then finally, you have the right to the assistance of counsel for your defense. We'll talk about the Gideon v. Wainwright case here in a moment, which is about effective assistance of counsel and when somebody gets the assistance of counsel due to indigent status, or essentially being in a position where they can't afford an attorney. Okay, so that was the Sixth Amendment that gives you a laundry list of protections for the citizens that are accused of criminal violations. What does the Fifth Amendment say? Well, we also have a laundry list here too. No person shall be held to answer for capital or otherwise infamous crime, essentially a felony, unless on presentment of an indictment by a grand jury. This section here is special because it's one of the few areas of the Bill of Rights that has not been incorporated against the states. So right now, the protection that says you can only be indicted by a grand jury only exists on the federal level as a constitutionally protected right. Some states have grand juries, not every state does because they're not required to. Oklahoma does not have grand juries for state level felony indictments. You just have the discretion of the district attorney who may or may not bring charges against you. But on the federal level, you have this right that any United States attorney wanting to bring federal charges against you, criminal federal charges of a felony level, then it can only be brought against you if they bring it to a grand jury, which is essentially an impaneled body of citizens who decide whether enough evidence exists to bring that charge. Okay. And then in green it says, no person shall be subject for the same offense be put twice in jeopardy of life or limb. Okay, for the same offense, you cannot be put twice in jeopardy of life or limb. This is obviously the double jeopardy clause that we may have heard of, the protection against double jeopardy in the United States court system. This has been incorporated to the states. It is a restriction on all courts that you cannot be tried twice for the same crime at the end of the day. We'll talk about that. Nor shall, in blue, you be compelled in any criminal case to be a witness against yourself. So when you say, I plead the Fifth, or I choose not to incriminate myself, or make statements where I might incriminate myself, that's what we all think is the only thing in the Fifth Amendment, but of course there's all this other junk in there too. And then you cannot be deprived of life, liberty, or property without due process of law. So the due process protection of the Fifth Amendment, this is what we call procedural due process or legal due process in the Fifth Amendment. Do not get that confused with the similar due process language provision in the 14th Amendment, which is about a broader version of due process. And then cannot be deprived of your private property taken for public use without without just compensation. There's a legal term for this. It's called eminent domain. So, you know, yes, ultimately governments may take your property, take your front yard if they're building a highway, whatever the case may be. This provision simply says it must happen with just compensation. And then, of course, we have the Eighth Amendment, which is pretty much the classic amendment on restrictions of government against infringing the rights of the accused, even the rights of the convicted. And this is where it says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Once again, thank you to the Constitution for giving us ridiculously vague language that we then have to send to the courts for interpretation once a case or controversy comes along. You can imagine, especially early on, that many convicted criminals said, oh, come on, this penalty, this sanction is definitely cruel and unusual, definitely excessive, not proportionate to the crime that I committed. Of course, we'll learn that the history of Eighth Amendment jurisprudence is that there's still quite a bit of deference to legislatures and judges when they decide what penalties shall be applied for certain crimes. Proportionality has become something of a joke in jurisprudence, that we tolerate quite a bit of disproportionality in our sentencing, and so far the courts have been pretty okay with that. So we'll start with speedy trial, trying to go through all of the colored sections as much as we can in as much depth as we can in one class period. A speedy trial. Well, in general, this means that criminal prosecutions should go to trial on the federal level within 75 days. We do have some case law on point about that. Unfortunately, there's not really so much a hard and fast distinction for what happens on the state level as opposed to the federal level. And in addition to that, even on the federal level, there are many possible reasons for delay that are allowed. For example, if more time is needed to conduct depositions, if more time is needed because of the complexity of the case, if more time is needed because certain witnesses are unavailable, so forth and so on. The courts don't want to force the state into a position where they weaken their case just because of haste to bring the thing to trial. And so what has happened is we've actually seen appeals go to the courts of appeal and even to the Supreme Court about, well, you've held me for as much as a year and my trial hasn't happened yet. Well, so long as there's some rational reason for the delay, so long as there's some reasonably articulable rationale for the government to say why the trial hasn't happened yet, there's going to be deference. So it's typically not a very useful provision for most criminal defendants. Might have intended to be that. The drafters of the Constitution might have thought in their head, gosh, you know, waiting a year before a trial seems unconscionable. Doesn't matter. That's not the way the courts have interpreted it today. We also have the presumption of openness for these speedy trials. What purpose might having an open trial serve? Open to the public, open to the press. Not necessarily meaning you're allowing cameras in the room, although some jurisdictions allow that. What we mean is people get to watch it. People get to put their butts in seats and watch the trial take place, watch the jury selection, watch the cross-examination of the witnesses, watch the opening and closing arguments. Why? Not to humiliate the accused defendant. In fact, quite the opposite. To give some scrutiny on the government's process and procedure behind the trial. Because prior to the Bill of Rights, prior to our Constitution being enacted in 1790, this was another one of those abuses of power by Great Britain against the colonists. Essentially closed door trials where nobody was able to tell everyone what happened. There were no impartial witnesses in the, watching the trial from the stands. Who could go outside and say, well, here's what happened. Here's the questions that were asked on cross-examination. Instead, it was sort of shady behind closed doors, no scrutiny by the public, no scrutiny by the press. And then I guess you just have to trust whatever the government says happened, because nobody can second guess it. Nobody can say, well, here's what I saw. So the idea behind a open trial is, at least in theory, supposed to be to protect criminal defendants against abuses of power by the government. However, in the modern world, there are folks who say, yeah, but what this ultimately leads to is a public shaming or a public humiliation on the part of the accused, who, at least during trial, has not yet been convicted of anything, and yet you've got all of their dirty laundry being aired in a public courtroom. There are, in fact, some criminal defendants who request, and sometimes get granted, their request for the trial to be closed to the public. After all, since the interest is a protection of the defendant, but they want to waive that right, well, then what problem is there with allowing that right to be waived? Typically, though, the trial will not be closed to the public unless there's some other rationale on top of the waiver by the defendant, such as their interest in privacy, or that the spectators to the trial are likely to cause so much disruption that it would be distracting to the process, so forth and so on. Okay. Cruel and unusual punishments. This is the Eighth Amendment rationale to protect criminal defendants. Well, the obvious meaning, if we're just interpreting the words cruel and unusual, cruel meaning, disproportionately harsh or painful, at least colloquially, and then unusual meaning not common, then we get to the obvious answer here, which is to say nobody can be sentenced to torture. There's no drawing and quartering in the United States, okay? There's no torture, intentionally painful deaths, or intentionally painful punishments, public lashing, okay? Being put in the stocks, things that we generally associate with, medieval times or shortly thereafter. Not so much in the United States today. No torture. That's the obvious takeaway from the Eighth Amendment. But you also have the rest of the language of the Eighth Amendment that says, okay, no excessive fines and no excessive bail. What does that mean? Well, for the most part, there's still quite a bit of broad leeway on what your fines can be if they're a criminal punishment, and what your bail can be if we're determining what secures your presence at trial. If we let you go, but we want you to come back for your court date, how much money does there need to be on the line to give you the sufficient motivation to make that court date? Okay. Well, the language that we have from prior court cases is that you can't have a grossly excessive fine that amounts to deprivation of property without due process. Okay. What if there has been due process, though? Well, then we're only looking at the grossly excessive portion. So ultimately, at least at the broadest sense, this means that, okay, a person who makes minimum wage can't be fined $1 million. That pretty much is obvious. But grossly excessive surely would fall short of $1 million. Here's the sort of unfortunate thing about this area of law. We don't have any really good cases that show precisely the range that the government may allow as a fine for a criminal defendant. This is one of those areas where we just don't have a lot of information. And so far, at least in terms of the fines that have been assessed so far against criminal defendants in the entirety of American history, there have been very, very few that have been ruled to be grossly excessive. We do know that bail must have some kind of reasonable calculation intended to secure presence at trial. We've seen people who are released for even first-degree homicide accusations in the millions of dollars, even when they certainly are not millionaires. So at what point does the reasonable calculation sort of go off the rails? I don't know. Once again, this is an area that the courts just do not seem to be very hard-nosed about enforcing. The proportionality of bail does not seem to be particularly tailored to any specific type of formula even, and can vary widely depending on what state you're in. You have some states like New York and New Jersey today that have all but eliminated bail. And then you have other states that have really excessive, well, I say excessive, really high levels of bail, such as Florida and Ohio. And the fact that there's a pretty radical disparity between those states, the federal courts do not seem to care, because you're allowed to have bail. The question is just, Okay, how proportionate is it? We do have a really good Supreme Court decision, Furman v. Georgia, that gave us some good clarity on the rest of things, at least in terms of what's cruel and unusual. It says that punishment cannot be arbitrary. It cannot be a punishment that is rejected by society. Obviously, that would be unusual. And it cannot be a punishment that is patently unnecessary. Taught a course a while back for Intro to Criminal Justice where we discussed humiliation-based punishments, which have been upheld, at least so far, by the court systems, especially for state-level crimes. You have people who, commit certain crimes on the state level, even sometimes misdemeanor crimes, and they'll be sentenced to, especially if you have a creative judge, maybe a certain type of community service that's directly related to the crime they committed. Or even more humiliatingly, you could have a person sentenced by a judge in state court that they have to go outside and wear a sandwich board, like you're selling something, where both sides of this sandwich board say, I have been convicted of whatever crime, and you have to walk around with it for a while. There's a lot of people who say, look, this seems to be really outside of the bounds of our traditional criminal justice system, that we shouldn't be intentionally publicly humiliating defendants. Now, there is, of course, the other side that says, well, maybe that is a great way to keep people from doing it again. Maybe we reduce recidivism this way. But at least so far, that type of punishment has not been ruled to be cruel and unusual. We do have some good case law on there shall be no death penalty for minors. Okay, that's actually the Thompson v. Oklahoma case. One of my law professors at the University of Oklahoma College of Law, Rick Tepker, that's the one case that he argued before the United States Supreme Court in the late 70s or early 80s, and he was appointed counsel for this individual who committed a capital crime while he was under the age of 18. And the Supreme Court determined as a matter of law that you cannot put a person to death as a penalty, even if they committed a capital crime, if they committed the crime when they were a minor. Okay. There's also a few other cases that decide that outside of constitutional reasons, but because of proportionality reasons and other considerations. There also shall be no death penalty for the mentally handicapped. That's not my phrasing. I know that's antiquated phrasing and might be considered rude to describe a person with psychological or cognitive impairments as mentally handicapped, but that is the language that the Supreme Court used when they made that decision. No death penalty for the mentally handicapped. Okay. Once again, keep in mind, I'm not requiring you to know case names. Just understand the holding in prior cases. I wouldn't give you a Supreme Court case that wasn't still good law, something that hasn't been overturned unless I told you so. Okay. So the Dulles case, 1958, said that it is not allowed in the American criminal justice system for one of the penalties of criminal conduct to be the revocation of citizenship if you were a natural-born citizen. We don't get to steal your citizenship from you and say you are now a completely stateless person. Okay. Even in the dicta, the long opinion written in the Dulles case, they said that such a penalty, at least in that court's eyes, would be worse than torture, because even a tortured person still has some type of constitutionally protected rights. But a person without citizenship seems like you're taking even that away from them. Okay. Not totally sure I agree that revocation of citizenship is equivalent or worse than torture, but clearly the court expressed their opinion that they do not believe that it is appropriate under an Eighth Amendment analysis to take away someone's citizenship. Notice they specified of a natural-born citizen. Does this, sort of have an inverse implication that if you're not natural-born, say you're naturalized or become a citizen by other means, that maybe you could have a revocation of citizenship? Well, we haven't had a case on point because ever since Trope v. Dulles, there's never been a law that would take away someone's citizenship, even if they weren't natural born, as a criminal penalty or sanction in the sentencing phase. Coker v. Georgia, 1977, says the death penalty is excessive for rape So no death penalty for rape so long as there's no death as part of the crime. So by implication, all non-death crimes can't be punished by the death penalty. Interesting. Although legal scholars would say that potentially treason, aiding the enemy during wartime, might be one of the rare exceptions to the Coker v. Georgia rule. It's just that we don't have any cases on point because, well, first of all, treason's really hard to commit. You've got to actually aid the enemy during a declared war, okay? A lot of people throw around the word treason like it means any type of betrayal of your government. Not necessarily. There's a specific definition. Okay. Graham v. Georgia, a recent case, look at that, 2010, says no life sentence without parole for a crime other than murder if the person committing the crime was a minor. So we're not just talking about death penalty proportionality here. Now we're talking about life without parole. Can that be a penalty for a non-homicide crime if you're a minor? No life sentence without parole for a crime other than murder for a minor. And then Miller v. Alabama expanded this to include murder too. So no matter what the crime is, you can't have a life sentence without parole if you committed the crime when you're a minor. Wilkerson v. Utah, really old case, 1878. But guess what? Hasn't been overturned. And it says that it is not a violation of the Eighth Amendment rights of the accused or of convicts to have death by firing squad. So long as all the other elements are met, such as it's proportional, this is, you would still apply the Coker v. Georgia test and all of these others. You can't, execute a minor. All that still applies. But so long as all those criteria are met and a person actually is, under the Eighth Amendment, allowed to be killed by the state, one of the methods may be firing squad. And in fact, you'll see that there are several states in the United States who, even though they have not used it in a long time, still have it on the books as a potential method of execution. Harmland v. Michigan, 1991, another case that has not been overturned, but sort of raises some eyebrows, allows a life sentence without parole of an adult for possession of 1.5 pounds of cocaine. This is where it gets into pretty controversial territory, and this is why I say the Eighth Amendment has not been the best friend of convicted felons. The Eighth Amendment, even though it says things about cruel and unusual, and we might reasonably believe that proportionality would be a pretty strictly applied rationale, especially since we're talking about the suspension of rights, well, you can be thrown in prison with no opportunity for parole, just for the possession of 1.5 pounds of cocaine. It strikes a lot of people as surprising, maybe not everybody, but it's not been overturned, okay? And then Rommel v. Estelle, 1980. The Supreme Court says they're okay with, they will tolerate under an Eighth Amendment analysis, they will not strike down as unconstitutional a life sentence applied because of a 3 strikes law if you commit 3 felonies over the course of your life in the same jurisdiction, even though the total amount of money stolen in these felonies was only $230. Not $230 each, the total amount of all 3 combined felonies was not much. There are several states with 3 strikes laws that say no matter what the crimes are, once you've committed your 3rd felony, we're throwing the book at you basically in terms of your sentencing. Okay? So you get these people who commit relatively you know, crimes which by themselves wouldn't be punished by more than a couple or 3 years in prison. But the combination of them, by putting together your 3 felony list, can put you in prison for life and be allowed under the 8th Amendment, even though everything that you stole only totals $230. Raises a few eyebrows that that's not been overturned yet, but it has not been overturned. Okay, so that was the 8th Amendment. Remember, hold your questions for next class period. I'm happy to answer them. Gideon v. Wainwright, 1963. I still find it funny that we discover new rights after the Constitution's already been in place for, you know, a couple hundred years. And here we are finding out that, okay, people who can't afford an attorney get one provided to them without having to pay for it. 1963. So what about everybody who didn't have a state-provided attorney prior to 1963? SOL, I guess. Clarence Earl Gideon, charged in Florida State Court with a felony, breaking and entering. Okay, think burglary. When he appeared in court without a lawyer, he requested that the court appoint one for him because he could not afford one. According to Florida state law, however, an attorney may only be appointed to an indigent defendant in capital cases. That was the rule at the time. Only in capital cases would the state of Florida give you an attorney. And so, because this was not a capital case, he didn't kill anybody. He's not accused of killing anybody. It's just breaking and entering. So the trial court did not appoint him an attorney. Well, you're kind of stuck between a rock and a hard place there. You can't afford an attorney. The state's not giving you one. So what do? Well, you either, you know, put together what little money you have and get the world's worst attorney, or you go ahead pro se, which is to say, without attorney. Ultimately, this was appealed, and Mr. Gideon won because the Supreme Court said that the 6th Amendment should be interpreted to mean that there is a right, a constitutional right to counsel in criminal cases for felony defendants or even non-felony defendants if they are at risk of imprisonment. So remember, we defined the difference between a misdemeanor and a felony to be, well, a misdemeanor is punishable by less than a year in prison, and a felony is punishable by a year or more. The way that this is interpreted under Gideon v. Wainwright is you get an attorney, even if you can't afford one, provided by the state, if you are a felony defendant, or even if you're just a misdemeanor defendant, but the state wants to throw prison at you as a potential sanction. Okay. Now, in practice, this means by far almost every criminal accusation, which means, you know, you get people getting jury trials on DUIs. Yeah, absolutely. And defendants win them more often than you might think. We've certainly discussed the exclusionary rule so far. Let's put a fine point on it. Evidence found in violation of the 4th Amendment or certain other restrictions on government authority must be excluded from the trial for the purpose of showing guilt. Now, what does this mean? The evidence can't be introduced at trial so long as the reason it would have been entered is to show that you committed the crime. This does not mean that it can't be entered for other purposes, such as to impeach a witness, including the defendant themselves if they take the stand. So if you get on the stand and you say, you know, I didn't own that gun, well, they can't introduce the gun as evidence that you hurt someone with it, but they can introduce it as evidence to show that you did own it, to show that you just lied on the stand and committed perjury. That's allowed. But it still matters quite a bit that the evidence can't be admitted for the purpose of showing your guilt, right? So this puts a significant restriction on the state if they violate someone's constitutionally protected rights in violation of the 4th Amendment or some combination of other amendments. So what's another type of situation where the exclusionary rule might apply? The Miranda v. Arizona case, 1966. You have this fellow, Ernesto Miranda, who's arrested in Arizona in his house, brought to the police station where he's questioned in a very police-heavy environment, not free to leave. He's questioned for hours in connection with a felony crime, multiple felony crimes, in fact. After hours of interrogation, he finally produces a written confession. Okay, so that's the question is, does that confession, does the piece of paper that he wrote or signed saying, I did this crime, does that get to be admitted into a court of law as proof of guilt? So what happened in this case is it was admitted into evidence at trial over the objection of the defense attorney. And the fact that the police officers admitted that they had not advised Mr. Ernesto Miranda of his right to have an attorney present during the interrogation. The jury found Miranda guilty based in part on the confession. As a result of this case, which of course overturned that decision and said that, nope, you should not have allowed the confession in, we get the Miranda rule, very famous and very frequently used by law enforcement today. The rule is that law enforcement must inform a suspect who is in custody and not free to leave of their right not to incriminate themselves as well as other rights. After these warnings are given, it is possible for a criminal defendant, an accused person who has been the subject of a custodial interrogation, to knowingly and intelligently waive these rights and agree to answer questions or make a statement or whatever. But the important part is that that prophylactic measure must be put in place prior to the interrogation. You must inform them of their Miranda rights. Okay. So here's the question though. What is a custodial interrogation? If Miranda rights attach, not at the time of arrest, but at the time that you are not free to leave and you are being asked questions about whether or not you committed a crime, or questions that would touch on whether or not you committed a crime. How do we define this concept of a custodial interrogation? Well, the obvious part is that you're not free to leave. So if you say, can I go? And they say no, you're probably in custody, right? Certainly not just a, a type of situation where a police officer is engaging you in conversation politely, right? Interrogation means questioning, and specifically not just questions that are like about the weather, but specifically questions that go towards guilt or non-guilt of a crime. Interrogation can also be broadened to mean indirect comments that the police know would elicit a reaction on those matters. The famous case on this, it's often referred to as the proper Christian burial speech. If you Google that phrase, proper Christian burial speech, you're going to get a lot of hits on websites that talk about Miranda warnings and whether or not comments made by police can elicit confessions in violation of Miranda requirements. So what happened was you had a guy who was arrested, and it was pretty obvious that he intended to confess eventually, okay? But he wanted to do it with his attorney present, and he wanted to make sure that he was following all the rules that protected him, okay? And he's accused of homicide. And this is a bad, bad case of a kidnapping and a homicide. And this is a bad fellow. But you have Miranda protections ever since 1966. So what happens is he leaves his attorney, and he's going to be put in a squad car and driven to another location where they can hold him, they can do, put the piece of paper in front of him, he can do a confession, all that kind of thing. And the police literally promised to his attorney, we won't ask him questions, we won't do any kind of interrogation in the car on the way there. You don't have to worry about that. So he gets in the back of the car. Well, lo and behold, it's a long drive, and the police they don't directly ask this fellow questions about whether he committed a crime. Instead, they intentionally make statements that are designed to provoke him into going ahead and confessing in the car. Okay. And one of those statements was sort of this long monologue by one of the police officers that's in the front of the car. And he says, you know, fellow, you've got, you know, we've got a missing girl, and that girl deserves a proper Christian burial. That's what he says. He says that girl, the family wants to bury this girl. They want to give her a proper Christian burial. And you're denying them that right now. He's trying to play towards the accused's emotions, trying to get him to go ahead and cry and go ahead and say, okay, here's where the body is, right? Well, it was successful. That's exactly what happened. They appealed to his emotions, and he starts bawling, and he says, okay, here's where the girl is. Now they can give her the proper burial. Well, now the question is, was that a custodial interrogation without having been properly Mirandized beforehand? And the Supreme Court said, yeah, that's a custodial interrogation. Even though you weren't directly badgering him with questions, he was still in a highly police heavy environment. He was in custody. He was not free to go. And even though there were not direct questions, there were indirect comments the police knew would elicit a reaction such as a confession. So it was so close to a custodial interrogation that, as a matter of law, it was a custodial interrogation. And for it to have been done properly, you would have had to have Miranda warnings first. Them being not given, that information that he confessed in the back of that squad car was ruled to be excluded at trial. We get tripped up on Miranda because of television. We get tripped up on Miranda because of Law and Order and any number of other television shows, NCIS, I mean, you name it. Because what they have done to over-dramatize the arrest scene is go ahead and start reading them their Miranda rights literally at the time of arrest, which not only almost never happens, is also never required, and is actually probably really bad police procedure for a bunch of reasons. First of all, your Miranda rights do not attach upon arrest. You don't have the right to have your rights read to you just because you're being arrested. It's about a custodial interrogation. In very few cases do the police immediately have to start badgering you with questions about whether you committed a crime. They just need to get you to the jail, okay? In many cases, especially if they didn't develop probable cause in the instance that they saw you commit crimes, they're just executing a normal arrest warrant. They're going out there and finding you based on other information that other police have dug up, okay? But even if you did see them commit a crime, why do you then need to ask them whether they committed one, right? So it's actually a very narrow category of arrests where you do immediately, as a part of good procedure, immediately need to start asking them things about whether they committed crimes. If you Mirandize them upon arrest, but then the custodial interrogation doesn't happen until later, then the Miranda warning might be stale by that point. Maybe they forgot they have rights, okay? You always want to Mirandize a person right before you actually start jumping into the questions. So this is why I say it would be bad police procedure for you to read a person their Miranda warnings at arrest, and then about 2 hours later, when they're at the holding cell back at the county jail, they actually start being asked questions. You don't want that Miranda warning to be stale, because a court might throw out whatever confessions or whatever really juicy answers to those questions that you elicit. And that's the last thing you want, is all of that really good evidence to be thrown out and be inadmissible at court. So do not believe television. It is highly irregular for someone to be read their Miranda warnings upon arrest. In a few rare cases, it does happen and might be reasonable. Also, it's not a get-out-of-jail-free card. Nothing about the Miranda warning system says, well, you failed to read me my Miranda rights, therefore you have to release me. And, you know, obviously, what's the first thing that a person says when they get to central booking back at the jail? They'll tell them, that officer did not read me my Miranda rights. You are violating my constitutional rights. No. And they're going to say that, and the person at central booking is going to roll their eyes because they've already heard it 7 times that day. Turns out you don't need to be read Miranda rights when they're slapping on the cuffs. If the custodial interrogee, we're not always just talking about an arrested person, but anyone in a custodial interrogation, if they request an attorney, which that's part of the Miranda warning, right? You have the right to an attorney. If you can't afford one, one will be provided for you. If they actually do invoke that right and say, I want an attorney, then the interrogation must stop immediately. If the interrogation does not stop immediately, any subsequent questions you ask and the answers elicited from those questions might be excluded. Silence by itself, if I just continue sitting here, my mouth closed, not uttering a word, while the police are asking me questions during my custodial interrogation, well, you can keep asking me questions. I'm just going to sit there quietly. That's allowed. If all they're doing is sitting there quietly, you can just, okay, question number 11 that you're going to ignore. Keep asking them. That's fine. However, if the custodial interrogee says, in so many words, I invoke my right to remain silent. I intend to stay silent. I'm going to be silent. I like that idea. I'm going to use my right to be silent. Anything along those lines, you don't get to keep asking questions. And in fact, if you do ask a question and then I answer it, that's not going to be usable information in court. On the flip side, if I was just one of those people who continued to be quiet without saying I invoked the right, and you're on your 7th question and I haven't answered the first 6, but all of a sudden I have an epiphany and I want to answer that 7th question, so long as I've been properly Mirandized, you could use that answer in court against me. Yeah. It's not the clearest distinction in the world, but I think it's reasonable. Breaks in custody. Basically, this is the idea that, okay, maybe you have a really long custodial interrogation. And there are rules about, you have to give people food and water, and you can't intentionally keep them awake or deprived of sleep. There are plenty of rules about that. We don't need to get into the weeds on that in this class. There are other classes where we can. But essentially, if there is a very long break between periods of custodial interrogation, like overnight, then it is generally proper that you need to re-Mirandize the person before you jump back into questioning. However, if the break is short, like a quick lunch break, and they already knew that we're going to come back to some interrogation, then you don't necessarily have to re-Mirandize. Okay. Exceptions to Miranda. Routine booking, questions asked when you're being booked into jail. What's your birthday? What's your full name? Okay. You don't have to be Mirandized, and you do have to answer the questions. So that's an exception to Miranda. They are questions. So people say, you haven't Mirandized me. I don't have to answer any of that. You do, if it's a routine booking question. Jailhouse informants. Let's say, and police do this more often than people in prison think they do, where they'll put a person in your jail cell, sharing your cell or wherever, sitting next to you at the lunch table in prison, who is faking being an inmate or is an inmate, a real one, but they're kind of working for the government on the side as an informant. There is no requirement that you be Mirandized. And this is because of the theory that Miranda is based on the intimidating nature of police action. That people shouldn't be forced into confessions because they're scared of a bunch of guns and badges around, and essentially the pressure of police presence. Well, in this case, even if you got a fake inmate who actually is a police officer, the thing is, you don't think they are. So you don't have this massive police presence or intimidation around you necessarily which is exactly what we're trying to protect against. So if you have a jailhouse informant that says, okay, while I was sharing the cell with so-and-so, he told me that, you know, he is appealing his case, or he thinks that he'll be found not guilty once it goes to trial, those types of things. But in reality, he really did commit the murder. He told me so. And then he told the story about how he did it. Turns out you don't need to be Mirandized before that. Obviously, if you did, you wouldn't have any jailhouse informants, because people would know, oh, okay, my, you know, fellow that sits in my cell with me would not normally Mirandize me unless they were a cop. Fair enough. So you can still get some jailhouse confessions through good police work doing those types of things. And then finally, the most obvious exception is the public safety exception. The classic case here where the public safety exception was really outlined by the Supreme Court was a case where a man was arrested, okay? He was not read Miranda rights. He's basically, think he's sitting in the back of the squad car, getting ready to be brought to the jail. Now, what is he being arrested for? Well, something to do with having a gun and pointing it at people, okay? It's just that at the time of arrest, he doesn't have the gun on him. Where's he arrested? A children's playground. So the police ask him, hey, can you tell us where the gun is? Because here's what's going to happen. Little Jill or little Johnny over there is going to find a gun and somebody's going to get hurt. So tell me where the gun is. They say that without any Miranda warning. So anything he says can and will be used against him in a court of law, right? So he answers, he says, okay, yeah, I don't want a kid finding the gun. Here's where the murder weapon is. Here's where the instrumentality of my crime is located. He gives evidence against himself. Turns out the courts say, because that question was asked for a public safety reason, it was not specifically asked just to prove his guilt or collect evidence of his guilt, that there is an exception to the Miranda requirement that you do not have to Mirandize that person prior to asking that question so that you can secure the public's safety. This would be the same as if you asked a person, where's your bomb at, after they phone in a bomb threat. Police are allowed to ask that. They don't have to read them the Miranda warning first before they say, all right, where's the bomb? Okay. Due process under the Fifth Amendment. Once again, not to be confused with the Due Process Clause in the 14th Amendment. They are separate things and they mean separate things, even though they use some similar phrasing. The core of due process is fair procedure. That you treat people the way that they would expect to be treated under our normal customs, our normal procedures within a court of law. Okay? What does that mean? Well, it means that they're not going to get assigned a judge whose house they robbed last year, because there wouldn't be impartiality, okay? So, the attorneys involved, the judges involved, the jurors involved have to be impartial. That is a core piece of Fifth Amendment due process. The chance to examine the evidence against you, the opportunity for your lawyer to look at it and see that it's real, to make sure it's not fabricated. That's part of the procedural due process of the Fifth Amendment. The ability to cross-examine witnesses. This is part of, getting to confront the witnesses before you. That's part of Fifth Amendment due process. Notice of proposed actions. So the notice of what charges, notice of what evidence, notice of any changes in those charges, you have a right to know. An increase or reduction of the charges, you have a right to know. The keeping of a tribunal record. What does this mean? Ultimately, it means a record of hearings in the trial, that there will be a transcript of words said so that the government can't come back and say, well, at this hearing, at arraignment, you confessed X, Y, or Z. Well, then you wouldn't be able to prove that that was a lie unless there was a record. So you have a right to there being a record of those proceedings. Usually it's verbatim by a professional. And then the right to produce evidence of your own. That not only the state gets to produce evidence at trial, but you, if you have exculpatory evidence, evidence that you did not commit the crime you have been accused of. This might include evidence of an alibi, Okay, great. You get to submit that and have that be considered by your impartial tribunal. That's part of Fifth Amendment due process. What is double jeopardy? There's a big movie about it that came out in the 90s. It was very, very popular and got double jeopardy all wrong. So if you've seen the movie Double Jeopardy, as some of you may have, it's a little antiquated now, but it was a big thing when I was growing up. Please be aware that the movie Double Jeopardy does not accurately describe double jeopardy. So what is double jeopardy? The Fifth Amendment says no person shall be subject to the same offense, be put twice in jeopardy of life or limb. So if you are if subject to the same offense, you are put twice in jeopardy of life or limb, then your due process right against double jeopardy has been violated. So here's, just the bullet points. If a defendant is acquitted, the government may not appeal. Why? Because that would be double jeopardy. You're being twice put at risk of life or limb. You just got acquitted and the government wants to bring the case against you again. No double jeopardy. Another hypo. If a defendant is convicted and his conviction is upheld on appeal, he may not thereafter be re-prosecuted for the same crime. Like if they wanted to get a stricter penalty for you or something along those lines. Or if they want to boost the charges from some lesser included crime to a greater crime on a re-prosecution. No, same fact, same case, same circumstances. You don't get to prosecute them again just to get something bigger as a result. If a defendant is not convicted, he may not thereafter be re-prosecuted for the same crime. So if you're acquitted, basically, you don't get to have the state come against you 3 years later and say, well, maybe we found some more evidence. We got a couple more witnesses. We think we got a stronger case. No. The state gets one crack at you, and if they fail in that one crack at you, they're done. Okay. And then under the dual sovereignty doctrine, we do have an exception here. It says multiple sovereigns can indict a defendant for the same crime. So if your conduct violated both state law and federal law, well, they're both sovereign. States are sovereign, federal governments are sovereign. Then yeah, that is actually one of those rare areas where they could both prosecute you for the same misconduct. Maybe it's even different crimes, but it's the same conduct that you're getting in trouble for. They can both prosecute you. So double jeopardy only limits one sovereign at a time, one crack against you. Okay. Before we get into policing strategies, I'm just going to go ahead and end today's lecture right here. I believe that we've met for about an hour. That should be sufficient for an hour and 15-minute class when I'm not actually there and there's no time for questions. So enjoy your Thursday. I will be back in class on Tuesday. Sayonara.